Hello, welcome everyone. I'm Lisa Decker. I am your host for today. I am a certified divorce financial analyst based in Metro Atlanta, Georgia. And I know that we have folks joining us from all over the country, and we have some speakers from around the country today. So I hope you're going to enjoy this webinar. I am also the founder of DivorcetownUSA.com, and Divorcetown is the sponsor of this webinar, where we hope that you will find all the resources that you need when you are going through divorce. And so today we are going to talk about, do I really need an attorney? And the dangers of do-it-yourself divorce. And this is a really timely and important topic. I know a lot of clients come to me and they want to find ways to save money, and sometimes they think they can handle the legal aspects themselves. And 99% of the time, I try to help them understand why that's not a good idea. So today we're going to have some experts talk to you about that. And you may see on your screen, we have three beautiful ladies here. We have Reagan King, who is an Atlanta-based family and special education lawyer, and Tori White. She is the owner and principal attorney with the Tori White Legal Group in Marietta, Georgia. And then Patricia Van Haren is a collaborative family law attorney in California. So welcome, ladies. We're going to cover it from coast to coast today. And first up, we're going to have Reagan. So if everyone else can mute themselves and turn off their cameras. And Reagan, I believe you have a presentation for us today. Is that right?
That is right.
Okay. All right. And Tori, if you are looking for your camera, it is up in the left corner. There you go. Perfect. Okay. So Reagan is as I mentioned, an Atlanta-based family and special education lawyer. She founded the law office of Reagan King in 2009. And in her practice, she focuses on helping couples, families, and parents in the Metro Atlanta area with difficult issues, including divorce, custody, and child support, as well as special education. Reagan takes a problem-solving approach to legal issues and is settlement-oriented, and she currently serves as the Cobb County chair of the Amicable Divorce Network, another group that I'm proud to partner with. And Reagan, always a pleasure to have you here to work with you with clients and to have you sharing your expertise with our audience. So I'm going to step off, and we will look forward here to hearing your information.
Thank you, Lisa. All right, I'm going to go ahead and open my presentation. All right. So today, Lisa asked me to talk about, as part of this, do I really need an attorney, the dangers of DIY divorce? What role should your attorney play? And I think that's a really important question. It's tempting to treat divorce like a home improvement project, right? Watch a few videos, read a blog or two, fill out the paperwork from the court. But like many DIY projects, we often find that it isn't as easy as it looked on TikTok or YouTube. We're bombarded with these words like child support, equitable division, parenting plan, settlement agreement, petition, and this can all be really confusing and overwhelming. But you don't have to do it on your own or figure out what all those words mean by yourself. You can get help from an attorney, and that doesn't mean that you are headed directly for expensive litigation, which I think is everyone's fear, that they're going to go through a divorce, get an attorney, and that attorney is going to blow things up and make it a really big, painful, expensive process. So a little bit about me. Lisa filled you in with a great introduction. Thank you, Lisa. This is me. I am located here in Metro Atlanta, pretty close to the Braves Stadium. I have been practicing in Georgia since 2008, and pretty much exclusively in the areas of family law and special education for the past several years. I've been working in the family law arena pretty much my entire career, and it is the bulk of my practice. So I'm very familiar with these types of issues in divorce. So why hire an attorney? So here's some real life issues that an attorney can help prevent. And I will try and go through this quickly. Attorneys are notorious for telling war stories and talking about issues. So the first kind of area where we see a lot of problems are just with financial mistakes. The first one being is the marital home. And I was a baby lawyer during the 2008 recession, so I saw a lot of things go wrong very early in my career. One of the most common things that would happen would be someone would agree to refinance the home in their name, and then they all of a sudden couldn't qualify. Or they agreed to sell the house and the market tanked, and they couldn't sell the house without taking a loss, which nobody wants. So over the years, most family lawyers have learned to develop strategies to minimize issues like that. I recently had a client who had multiple properties. The husband was supposed to keep the marital home and buy out the wife, who was my client. But after they signed and submitted their paperwork, all DIY, they decided that my client would stay in the marital home and the ex-husband would move to Florida. And then there was this other property located in Michigan that was under contract for purchase at the time they submitted their settlement agreement. But the closing fell through and there was no contingency plan. So what happens after all of these significant changes, because they didn't think about potential issues? Well, messy, complicated litigation. There aren't great ways to fix a poorly drafted settlement agreement. And eventually we got it all worked out. But both parties would have spent less money had they addressed these issues on the front end and had an attorney sat down with them and said, okay, but what if plan A falls through? What's plan B or plan C? And so those types of issues come up frequently. I had another case where a client in their divorce, and again, another DIY, the husband agreed that after they sold the marital home, he would get other housing for his then ex-wife, who I represented. But there were no details about what the maximum cost would be, how they would pick it, whether it would be rented, purchased, anything like that. And again, this led to messy, expensive litigation where the judge was forced to try and determine what the intention of the parties was at the time of the divorce. And both parties spent over $100,000 in legal fees in this modification action, which, to be fair, included other issues, because guess what? When there's one issue that's poorly resolved, there are likely other issues that aren't resolved. And again, had an attorney sat down with this family when they did their uncontested self-written divorce, a lot of these issues could have been avoided. Child support and expenses for the children. This is another area where people tend to misunderstand what their new budget is going to look like. And so they overextend themselves or they take less support than they really need. In Georgia, at least, child support is more or less set by statute. There's worksheets we run, and attorneys run these worksheets all the time. We know what information is needed to get it right. And we also know how to address some like irregular expenses, things that maybe don't come out all the time, or things that are unique to your situation. So this is an area, again, where an attorney is extremely helpful in making sure you don't have errors. I had a case that came to me, again, another DIY divorce, where the parties agreed that they would each, instead of paying child support, they would each split the cost of reasonable and necessary expenses for their child, and kind of had a list of the types of things that might be included about that. And so at first that was great. And then they started disagreeing about what reasonable and necessary expenses were. And again, this is a situation that led to expensive litigation that could have been avoided had the parties retained attorneys at the beginning when they actually got divorced. A third area where there's common financial mistakes is that parties are really always concerned about undisclosed assets and debt. People always think their ex or soon to be ex has some hidden giant account in the Cayman Islands. And most of the time that is not true. With an attorney, an attorney will make sure you request the appropriate financial documents so you know what actually is there. There's almost always a paper trail when it comes to the money. And if something looks suspicious, the attorney will recommend that you hire a forensic accountant to see where that money actually has gone. Now, what's more likely and more frequently happens is there are undisclosed debts people don't know about. So an attorney can help you make sure you've run credit reports to see what actually is in your name, or even have you run a title report before we decide what to do with the house in case your spouse ran up a bunch of credit card debt, didn't tell you about it, and had judgments against the home. There's other common mistakes with timing. When are things going to be due? When are things going to transfer? Tax issues. Most attorneys are going to tell you, I'm not a tax expert, but we know the issues and know when to tell you to go seek that expert advice. The other big area in family law where people make mistakes is issues with parenting plans. So poorly defined custody and parenting time is a huge issue. If you're going through a divorce with children, maybe it's your second divorce, but for the most part, most people are going through this for the first time and they don't have any idea what they're doing other than what their friends have told them. Yeah. And if everything's going well, they may think, oh, my ex would never keep the kids from me. So again, I recently had a case where the original parenting plan said, fathers shall have reasonable parenting time at all times in which mother allows. Well, that went great until they stopped getting along. And since it was whenever she allowed, he never got to see his child. I've had other cases where there was a final decree that was not clear who had primary custody, and there was no parenting time. So it was very loosey-goosey, willy-nilly, things like that. And a really good drafted parenting plan will include those kinds of things so everybody knows what the rules are. Another problem can be unclear decision-making rules. Who's going to decide what doctor you're going to see, where the child's going to go to school, what extracurriculars are going to be involved, the child's going to be involved in. All of those things have to be decided, and attorneys have experience negotiating those issues, offering you options. One thing I saw, again, relatively recently was an overly broad right of first refusal. So right of first refusal is really common. If you're going to be out of town overnight, the other parent gets to have first dibs on the kid before you go and hire a babysitter or, something like that. But this particular case had a carve out and said that time with the grandparents didn't count. So what dad did was basically move his child in with his mother, and it prevented the mom from having custody of the child when the father had no intention of actually exercising custody. There can also be strange lasting implications. I was recently in Pike County and for a long calendar call, and a woman was suing for legitimation after her father had died because in her parents' divorce decree, they said they didn't have any children. So I don't know what happened with that case, but it was one of the weirdest things I have ever seen. And you don't want to prevent your children from being able to inherit just because you're trying to avoid a parenting plan or something like that. The last thing that comes up frequently is that parents don't know how to adequately address substance abuse issues. Unfortunately, that is something we as family lawyers see all the time. It's very difficult to be married to someone who has an alcohol or drug problem. But we have tools in our toolbox that we can use to help ensure your child's safety while still maintaining a relationship with the other parent. So there are types of divorce. There's uncontested, amicable, traditional divorce that I am familiar with and that I practice. I think a lot of us did not realize that there were so many options and, how do you choose which one is best? When you consult with an attorney, part of what they do should be to talk about the different processes available in your particular jurisdiction and help you decide what makes the most sense. So I'm going to start talking about traditional divorce. This is the default method. The pros are it is a litigation process. It is something attorneys are very familiar with. We have the option of discovery. The court can address temporary issues. And if you're not able to resolve the case with the assistance of your attorney or with the assistance of a mediator, the judge will decide your case. So there is an end in sight. The cons are that the cost is unknown. The court system's public, which means all of your personal financial information about your children, maybe you had an affair with your boss, maybe your spouse did, all of that is out there in the public where people can find it if they really want it. That's not quite a Google search, but it's there. The other thing you're dealing with are the court rules and scheduling. So in Georgia, many of the courts have standing orders. Some of those standing orders prohibit you from going out of state with your child. So if a divorce is filed and you had spring break planned at Disney World, all of a sudden you may not be able to go on that trip, which is very inconvenient, causes parents to lose money, very frustrating. You also can get called in to court virtually any time, which can be difficult if you're trying to manage all of a sudden being a single parent and maintaining your job. The next type of divorce I want to talk about is uncontested divorce. So we see signs for this all the time, billboards, things like that. And it is actually perfect for couples who agree on all of the issues for the divorce. It is fast. It is typically affordable. A lot of attorneys will do this on a low cost or a flat fee basis, so you know how much it's going to cost at the onset. The cons are, as a layperson, you don't know what you don't know about divorce. So you may think you have an agreement on all of the issues, go draft up your paperwork, and you've missed things. And so again, this is an area where having a lawyer who knows how to fill in those gaps can be really critical. And then, as Lisa said, I'm the chairperson for the Cobb County branch of the Amicable Divorce Network. And this is a relatively new process. It is a great process. So it is a perfect kind of hybrid of couples who need more help than the traditional uncontested divorce, but still want to avoid court. Some pros are that you can set your own schedule. You decide when you're going to mediate, things like that. It's private. Nothing's getting filed with the court until the very end. And it's considerably less expensive. Most of the attorneys who are members of the network offer a reduced fee, a reduced retainer. And because you're outside of the court system and doing things based upon contract and agreement, it's faster and cheaper. The only con I could come up with for this process is there's no day in court. Now, both parties would have to agree to this. This is a voluntary process. It's not mandated. But if both parties are on board, it works great. And you don't have to get along to participate in it.
Hey, Reagan, I just need you to give you the 60-second warning. You're giving such great information.
Okay. So I will rush through this as fast as I can. I'm going to sound like the old Micro Machines guy. So what is the role of the attorney during the divorce process? One is to be advisor and counselor. We're listening to the private details of your marriage in a confidential setting. And we're presenting options based on prior experience. This is different than being a therapist, but we are providing practical solutions that we know we can implement in the important documents. We're acting as a researcher, both understanding the facts, things like finances, things that might impact your children's well-being, and bad behavior of the party. We utilize processes like discovery or informal exchange of information to make that happen. We're also there to explain the law, research the law, and how your particular facts might impact a judgment in court, which helps you reach a settlement. And finally, and I think this is what we're being hired to do regardless of what type of situation it is, we're author, editor, and publisher. We're creating documents for you. We're helping you review and edit documents. And we're presenting documents to the court so you can be divorced. And different attorneys will handle this in different ways, but even in an uncontested situation, you can hire an attorney to review those documents and give you some feedback. And that does not have to be very expensive. You can also hire an attorney to do everything from start to finish. Lisa, is there time for questions or no questions?
Well, we're going to do Q&A at the end, and I think you gave a lot of great information. So I'm looking forward to hearing what questions come up. Thank you so much, Reagan. That was wonderful.
Thank you.
Okay,
Thank you.
Up next we have Tori White, and Tori resolves to help keep families out of court by providing alternatives to litigation by working as a mediator and arbitrator in domestic cases. She also works as a guardian ad litem on behalf of children's best interest in high conflict custody cases. And Tori was recently selected to serve as one of 3 Cobb County adoption investigators for the Cobb County Superior Court. Oh, I love that. Tori has served as the subcommittee chair for the Georgia Association of Women Lawyers Leadership Committee. She is currently a volunteer lawyer with the Atlanta Volunteer Lawyers Foundation, and she provides pro bono guardian services during the COVID-19 pandemic. She lives in Smyrna and shares the love of one judicious but loving German Shepherd named Flynn with her boyfriend, Ryan. And I love that too. I love these little tidbits. So glad to have you here, Tori, and I will let you take the floor.
Well, thank you, Lisa. I appreciate the introduction, and thank you for the opportunity to speak on behalf of keeping folks out of court. I'm passionate about this process and would love to share with folks the options going forward as they navigate their particular concerns. Even winners are sometimes losers, right? And I'm going to say that one more time. Even winners are sometimes losers. Never more relevant in context than applied to the context of litigation. Litigation is fraught with risk and cost. And today I'm going to share with you some of those risk and costs, and then I'll share with you an option, an alternative to litigation. Litigation is adversarial. It pits one party against the other, the V in the middle. As Reagan alluded, it can be very expensive. There are hard costs associated with litigation, such as the attorney's fees, utilities, technology. We forget about, someone has to keep the lights on at the courthouse and pay the deputies and staff attorneys. Those are costs that are absorbed by the folks in the community and shared with us. And then there's soft costs involved, the emotional turmoil. It's frustrating when you've been called to court on October 1st and you've taken off work. They only gave you 2 weeks notice, and you show up and only to be told that your case has been continued. And that's the second time or the third or the fourth. So those emotional frustrations on that rabbit wheel can get quite frustrating. And there's that soft cost associated with going to court. Litigation can also be destructive of relationships, especially when you are trying to co-parent or preserve a relationship. Litigation can compromise any civility that you have developed up to that point. It's characterized by winners and losers. And that's not so fun. It doesn't sit well. But there is an option, and that option is mediation. Mediation is less expensive. It's cooperative. It's quicker. We're no longer at the mercy of the judge's calendar, which can be quite long, especially in post-COVID days. And I'm so happy to say one day that we will be post-COVID, fingers crossed. But as the docket fills back up, these civil cases will have to demur to the criminal cases, and things will get a lot more congested. So mediation is a quicker option to going to court. Mediation is also confidential, and that's the touchstone of mediation is confidentiality, and we'll touch on that in just a minute. We'll do a deeper dive. But as Reagan alluded earlier, public open court, it's just a matter of a click of a mouse nowadays, and your entire Facebook friends community is now listening ears in your divorce drama. So imagine having that experience nowadays. Mediation, contrary to litigation, is supportive of relationships. It's often a friendlier, more cordial atmosphere. It's less formal, and it's certainly conducive to managing or supporting relationships rather than that V in the middle. And it's characterized by all winners, all parties being winners. That's the beauty of mediation, where all interests are met at some degree. That's not the case in litigation. Again, even winners are sometimes losers. Now, what is mediation? The formal definition is that it's a trained neutral person like myself. It's called a mediator, facilitates the resolution of a dispute between 2 or more parties. Mediation is non-adversarial, and the objective is that you help the parties reach a mutually acceptable agreement. As I alluded earlier, the key component to mediation is confidentiality. It's the touchstone, it's the foundation block. Confidentiality is a powerful process because that means that any party that participates in mediation may not disclose the communication that went on. So at the end of the process, I'm not giving the judge a phone call and saying, hey, Your Honor, these parties discussed this at mediation. That doesn't happen. What types of disputes can be resolved at mediation? Several, if not all. Landlord-tenant, commercial, consumer law, personal injury, and certainly domestic law. Even at times, domestic cases that have involved domestic violence can be resolved at mediation. Particularly in our present times, as we are mediating on online platforms, you may find that cases like that involve domestic violence, it's a safer environment to mediate, and that you won't have that opportunity in going to court, where it's confronting the other party directly. Now, at the mediation table, what's my role? Well, obviously, I explain the mediation process, and I provide a supportive, non-confrontational setting in which to negotiate. I'm going to assist the parties to understand and analyze the facts and the issues, and then I'll keep the parties focused on the issues. I help the parties gain control of their dispute by helping them gain control of their emotions. As you can imagine, and especially in domestic cases, emotions are controlling. But we gain control of those emotions and by facilitating creative and cost-effective solutions. I help parties overcome impasse. By doing so, I might meet with the parties together or separately, or back together or separately. It just depends. What about the attorney's role at mediation? What are they doing? Well, obviously, they're giving legal advice to their respective clients. They're also providing an opening statement and a practical application at mediation, setting forth the issues that we'll discuss. They propose settlement options. They're reviewing the other party's documents. They're also writing language to include in these parenting plans or settlement documents, etc. You may find that mediation is appropriate for you. Mediation is required in many counties, but it's still a voluntary process. It's called voluntary because you can walk away at any time that you've begun the mediation. But you'll find that it's particularly useful to use mediation is when you're committed to the process, or when you have an ongoing relationship, like with a co-parent that you want to preserve, or when privacy is important. I can't stress enough that confidentiality is the keystone to mediation. You don't have that option in going to court. Working as a guardian ad litem, I've often seen high conflict parties engage with one another, and their children are left in the dust, and their children's concerns and issues and significant privacy issues are splayed out for the public to then one day Google and find. And that child has to read about themselves in a really salacious manner, and that can be cruel. So one way to eliminate that opportunity is to mediate wherein the boundaries of confidentiality. You also may want to mediate when there are time constraints to settle. When you've got to get divorced because you've found someone anew, it may be a process that you pursue outside of the court, going to court, because it's quicker. Again, you're not beholden to the judge's calendar, but your own. When you're selecting a mediator, what are you looking for? You're looking for someone who's trained and skilled and has experience. Now, competent mediators come from all walks of life and professions, and they employ different styles. Among other factors that you want to consider are a person's experience, their reputation, advanced degrees, or mediation training. Now, here in Georgia, the Georgia Office of Dispute Resolution registers mediators or neutrals. There's usually a hosting component in each state, and will outline the boundaries or the protocol for getting registered in that particular jurisdiction. When you're selecting a mediator, you also want to consider your personal preferences. For example, do you want a mediator who is facilitative, or a mediator who's evaluative, a person who suggests options, or someone who's less directive? Those are options when selecting a mediator. Appearing pro se at mediation can be fraught with difficulty. If you represent yourself at mediation, you step into the role as your own attorney. I see this working against pro se litigants quite often and at different phases of the mediation process, but never more so than particularly at the time of settlement. Once the parties reach an agreement, you can be bound to the terms of this agreement on a final basis, which can have long-lasting effects in cases of divorce financial settlements or parenting time settlements. Now, I've shared with you the costs associated with going to court. I've also shared with you the option available, which is to mediate. Thank you, Lisa.
Thank you, Tori. That's great information, folks. I'm a big proponent of all kinds of alternative dispute resolution methods, and mediation is high on that list. So I hope that everyone is taking notes, and we will be coming back for questions and answers after we hear from our next speaker. So up next, we have Patricia Van Haren, and she is a collaborative family law attorney who works with families who are looking for a way to minimize the impact of divorce on their children and gives them a process to restructure the family unit without destroying it. That's so important. Starting in January of 2021, Patricia works solely as a collaborative attorney and mediator. She has a child-focused practice and seeks to assist families in minimizing the impact that divorce can have on families as a whole. She believes in educating the public and providing her clients and the public the ability to be informed in the divorce process, right in sync with what we're doing here. And she regularly publishes blog articles, creates educational videos, hosts workshops, and has written a book intended to educate people who have questions about divorce. In her free time, she enjoys spending time with her 3 adult children and 2 dogs. And Patricia, it is great to have you here. I'm going to give you the floor now.
All right. Thank you so much. I am going to just pull up my slideshow here. Hopefully you can all hear me. So chat if you cannot. So dangers in our do-it-yourself divorce. So we've got dangers of self-representation. And what I've seen is, trying to save money can actually end up costing people more in the long run. So what options are out there? You can have a full litigation model with self-representation. There's self-help centers at the courthouse, paid document preparers that are not attorneys, LegalZoom, mediation with non-attorney mediators, or mediation with an attorney mediator without any type of independent counsel. So these are some of those do-it-yourself options.
Patricia, I want to stop you for just a minute. Maybe move the mic a little bit. We're getting some feedback there. So I want you to be focused on what you're saying, not how it's being said. Thank you.
How is that? Is that better?
Yes, perfect. Thank you.
Oh, okay, thank you. Sorry about that. So why is this dangerous? So self-help is not helpful. At least in California, our self-help centers cannot give you legal advice. They can only show you how to complete the forms. Oftentimes, they don't even tell you if they are correct, if you filled them out correctly. They're also not able to discuss any of your divorce options with you. So they're going to help you with forms and send you up to the judge. You're expected to know the law when you represent yourself in court. You're expected to know the laws, the rules of court, and all the procedures, just as if you went to law school. Mediators are not your attorney. So when I'm acting as a mediator for a couple, I'm not able to give them legal advice. I can give legal information. And as I explain to my clients, I can tell them what they can do, but not what they should do. So if I'm acting as a mediator, I always want to guide my clients to get independent legal counsel in case they have questions. And you don't know what you don't know. And I heard another one of our presenters say that. Divorce is complex, and there's many variables that you're going to consider when you look at support, child custody, property division, and you're not always going to know what your rights or responsibilities are if you're not educated in the laws of your state. Therefore, it's important to have some sort of guidance by somebody that does know the law. So what are your options then if you don't want to spend a lot of money on legal fees? You can have a consulting attorney. And what a consulting attorney is, they can consult and provide counsel when you're going through mediation, either with a non-attorney mediator or an attorney mediator. They can also, you can use a consulting attorney to provide counsel when you're self-represented in litigation. They can assist you maybe with your paperwork only, making sure that that's done correctly. And in California, we call this as a limited scope attorney. And sometimes people can hire a limited scope attorney to just represent them for certain court hearings. So your benefits of a consulting attorney. So in mediation, your consulting attorney can help you prepare for your mediation sessions. They can put together a list of questions, different options that you may want so that you can present your proposals. They can review any documents that are prepared before you sign them. Make sure they're accurate. Make sure you understand them. They can provide guidance on what you may want to request in regards to orders. And they can help you formulate proposals prior to your mediation. Consulting and litigation, they can tell you how to complete the court forms. They can make sure that what you're asking for is actually matched on those court forms. They can help you determine what orders you should request in regards to child support guidelines, spousal support guidelines, property division or custody. And they can guide you on what arguments you can make if you're going to be arguing your case in court. And in document preparation, they can assist you in preparing an enforceable agreement. The last thing we want is to put together a judgment, which I think we heard some nightmares from one of our earlier presenters, that causes you to later on end up in litigation. You can ensure that all your forms are not vague or ambiguous, and they can instruct you and assist you with the proper filing procedures. Collaborative divorce is another option that is much less expensive than litigation. So in a collaborative divorce process, each spouse is going to have an attorney, and they're going to provide them with legal guidance and advice. The attorneys make a commitment to stay out of court and work as a team, and these attorneys will sign a disqualification agreement, which means if the case goes into litigation, neither attorney will represent the parties in the process. And then you can build your team. You may choose to have a financial neutral. So rather than spending money on competing forensic accountants, you hire a joint financial neutral, and they're retained to assist the parties and their attorneys in coming up for options as far as support and property division. You can have a divorce coach or facilitators. They can also act as a child specialist, and these facilitators can help manage emotions and resolve conflict in the process. A lot of what escalates attorney costs and legal fees are emotionally charged arguments and emotionally charged positions. So collaborative divorce is a team approach, and each professional is working together. And the goal is that the parties can create agreements that will last for years to come and put an end to the litigation. So benefits are private and confidential. So nothing said in the collaborative process can be used in court. The same protections apply in collaborative divorce as apply to mediation. The only items that are actually part of the court record are legal documents submitted to the court in order for the divorce case to be processed. Again, we have that team approach. Often because we're using a financial neutral or a child specialist, the fees that are spent on attorneys will actually decrease. Also, you're learning skills to help you better communicate with your spouse. This means that in the future, you'll also be able to communicate better, and you're less likely to end up in court after your divorce. And the collaborative divorce is child-centered. I really believe that no one knows children better than their parents. And therefore, I find it's best to have parents that are actively involved in creating a parenting plan. The team can work together to design the right plan for those specific children of the couple. In court, a judge is a complete stranger, and they're going to create a plan for your children. And often, at least in California, our courts are very overcrowded. So maybe a judge is going to spend 15 minutes, an hour with these parties, and they're going to put together a plan that's supposed to determine custody and what's in the best interest of the children. Divorce mediation. So divorce mediation is much better than litigation. And there are still reasons why you should have your own attorney, at least to consult with in mediation. So what you can resolve in mediation: child custody and visitation, spousal support, child support, property division. All aspects of your divorce can be resolved in mediation. Our benefits are, again, it's private and confidential. Nothing said in mediation can be used in court. The only things that are a part of the court record are your legal documents. So the divorce petition, the response, disclosures. So things that are submitted in order for the divorce case to be finalized. Mediation is less expensive than a litigated divorce. Neither party goes to court. They're not fighting with attorneys. And for a couple with minimal conflict over property, support, or custody, mediation's often the right option. With mediation, you run the show. Some couples resolve all the issues in 1 or 2 mediation sessions. Some resolve over a series of sessions. But you and your spouse are really going to determine the pace of your mediation and how many sessions you need. So why use an attorney if you have a mediator? So the mediator does not represent you. A mediator is a neutral party. They're going to assist you and your spouse in coming to agreements together. But it's important to know the mediator is not your attorney. The mediator is not your spouse's attorney. And they can give you legal information. They can tell you what the laws are, what options are available, but they can't give you legal advice. So I always encourage my clients to consult with an independent counsel before they sign a final agreement. And your attorney can also, excuse me. Sorry, my throat is getting dry. Your attorney can also help you come up with proposals. So you may have an idea of what you'd like to have in your judgment, but you might not know what should be in there. And this goes back to you don't know what you don't know. Your attorney can help you before your mediation session so that you're prepared to negotiate and you have the correct information about what your rights are and what are your responsibilities. So my office now offers a unique solution. And I saw the need to have additional options for people who wanted to minimize divorce expenses. As I said, self-help is just not helpful. So we created a tool to simplify the divorce process in California. And what we have is an online attorney-assisted solution. So how it works is we have 3 simple online interviews. Our clients put in information to help get together documents to file and serve those initial court documents. And that's when our waiting period begins. Step 2 is the exchange of financial disclosures, such as income and justice. I apologize. We've been having these winds and my allergies are just acting up today. So our second step is the exchange of financial disclosures. In California, we have income and expenses and assets and liabilities. And our third step is to put together your final judgment. So why we did this? We saw so many families come in after the divorce was final to correct problems solved by self-representation or these online divorce mills. And when your documents are done incorrectly or something's mixed, it can be really expensive to fix. And there's many cases that end up in litigation.
Patricia, we're sorry you're having so much trouble. I know you've got a lot of fires going on out there, and it's probably difficult for a lot of folks. So just take a minute and catch your breath.
Thank you. I am so sorry. Yeah, the weather is just killing my throat. So sorry about this.
It's okay.
Okay, let's try this again. So cases end up in litigation often because the final judgment is ambiguous. Each party has their own interpretation. Then they get into an argument, they're no longer getting along, and they end up back in court. We also want to make sure parents have accurate parenting plans in place. And we don't want to see cases litigated where parties may actually agree, but because of that lack of communication, they don't know it. The self-help centers and document preparers aren't allowed to give legal advice, and they don't know what should be included in a judgment. So our online interview makes sure that all scenarios are covered, and then I go ahead and check all these documents for accuracy. Oops, and that is the end of the slideshow. I meant to delete that last one. So thank you so much, and thank you for bearing with me while I had my coughing attack during this process.
Well, I'm glad you made it through it, and you persevered. So that shows fortitude. Truly, you know, the fires out there in California are causing a lot of breathing issues. So we hope that you remain well through this.
Thank you.
So now it's time for all of our speakers to come back on camera and back on audio, because we do have a few questions. And Marcella, if you wouldn't mind, you know, letting us know what those questions are, we greatly appreciate it.
Absolutely. We do have one person with their hand up. If you don't mind putting your question in the question box, we will absolutely get to it. First, I want to start with someone who is in Georgia. They were deployed, got back home, found out they were divorced, and everything they owned is gone. And this person thought there would be something in place to protect service members while they are deployed. Can either Reagan or Tori speak to that for Georgia?
You guys may need to unmute.
Yeah, let's turn mics on.
I'm having difficulty understanding the question. I believe that she said that her property was taken.
So they were out, they were deployed, and when they returned, they were divorced basically and everything, yeah, everything was gone. Is there any protection in that instance, or is there anything, is there any recourse?
There may be recourse for her. There is a Military Service Protection Act, which, if you will, pauses divorces and the pendency of divorces while military service folks are protecting our country. There may be repercussions for divesting someone of property while a divorce is pending if you filed under the Military Service Protection Act.
Thank you for that. Also, go ahead.
I would just add to that if that's the situation, definitely consult with an attorney sooner rather than later, because oftentimes there are time limits on invalidating a judgment like that. And, you know, if property's been sold to what's called a bona fide purchaser for value, even though you may have recourse against your spouse, there may not be a way to get back a house, a car, something of that nature. So definitely seek out advice. There are different options available. And that would be your best course of action.
Excellent. Thank you for that. We have another question from Georgia. Does a consulting attorney advise both sides or only represent one party? We have over $50,000 in legal fees to litigation-minded attorneys so far. Lawyers are not helping us get divorced. Unfortunately, a common problem.
It is a common problem. And so an attorney can only advise one side. We have significant conflicts rules, so we can't give advice to both parties. I'm sure there's somebody who could say, well, you could pay me for an information session, something where I'm not providing advice to either of you. I have never done something like that. I think it gets into a very kind of nebulous area as far as our ethics rules. But if you wanted to pay for a consultation with an attorney, most attorneys are happy to sit down with you, talk to you about your case, and how he or she might handle something differently, and give you some feedback. Oftentimes people come to me and say, oh, this case is going horribly. And then I sit down and I look at it and I say, well, actually, this is very similar to how I would handle it. And other times I say, oh no, you're absolutely right. This is a disaster. Tori, if you have any other feedback on that.
I echo your sentiment, Reagan. Exactly.
Excellent. And also, if parties are interested in collaborating, there are other options. For example, Lisa, as a financial neutral, can work with both parties together and where the attorney and reach agreement, and the attorneys would be there to draft the language and make sure that the I's are dotted and the T's are crossed. So that is another option as well. Couple more questions we have. How does one start the process of mediation to divorce? Is there a filing done prior, or does the attorney hired file and then mediation starts? So maybe you guys can help us with how that works.
It can be either. It can be either way. So you can have a mediation prior to filing as a private session, or you can mediate while the independency of the court case. It just depends on where you are in your thought processes and where you are in the collection of information. One tidbit or one important point of advice is always show up to mediation with documents, right? It's a document-heavy session, and so if you don't have documents with you, you're probably not ready to mediate. So it just depends on, but you can certainly come together and mediate prior to filing for divorce, or again after you filed for divorce.
And in California, usually our process, the way we do it is, if it's a private mediation, then they would come in and both parties would sit down with me as a mediator, and we would, in our first session, discuss who's going to be the petitioner, who's going to be the respondent, and go through the filing process together. We come to agreements on service. Are we going to do an email service? So, and then in other cases, parties have attorneys already, and the attorney would reach out and say, hey, my client's interested in mediation. And so the attorney would be preparing all the paperwork for them, and they'd be coming into the mediation sessions to discuss the issues.
And as a divorce financial analyst and a financial neutral, I would also add that on top of just having the documents, I think that being clearly prepared for understanding what mediation is about, what is going to happen in the process, what is it that you want to accomplish, what are your goals? A lot of times people aren't even clear on that, and so how can they know if they are working towards getting to where they want to be? And really understanding the depths of your finances, because many times people do not have a clear understanding of what their net worth is. Excuse me on that. And they don't understand what they own, what they owe, what may be owed to them. And so if you want to have the best shot at settling at mediation, whether it is a private initiation that you and your spouse are working with a private mediator, or whether it is court mandated mediation where you're working with attorneys, either way, walking into your mediation prepared to make an offer, to accept an offer, to get settled that day. The only way that that's going to happen is if you understand the numbers that apply to your life situation. And that's what I find most people do not understand. They also don't understand the mechanics of mediation. And so working with a good divorce coach or mediation coach or a good attorney who can advise you ahead of time of what to expect can go very far in helping you make the most of that day, because mediation can be one of the most important days, not only in your divorce, but in your life. And a lot of people don't take it seriously enough, and they just think that it's a waste of time and money. My spouse will never agree to anything. This is a waste of time. I'm going to head to court and let the judge know. And that's unfortunate attitude, because most of the time, and you ladies can all speak to this as attorneys who speak before judges, but most of the time the judges are very busy. They've heard the similar things before. You're not going to get your day in court to stand there and tell all your grievances. It's very matter of fact. And mediation is going to save you a lot of money, because you're going to spend tens of thousands, sometimes hundreds of thousands of dollars more heading to court. And these are the things that we want you to know up front. All of us who work in this world of settlement-minded, resolution-minded divorces. I do apologize. So anyway, let's see what else we have here, Marcella. Any final?
We do have just a couple more. In this case, we have someone with adult children, property has sold, no other real shared assets or responsibility. So what is the most effective path? What would you recommend to have the minimum of advice given, no complications or complexities?
So first, definitely sit down with an attorney to talk about options, because it may seem like there are no complexities, and you may be right, but let's double check that first. Because there may be things that you're not thinking about, like an old pension plan that we're going to need to do some sort of qualified domestic relations order for, or something of that nature. Even just transferring title in cars can be like a little difficult. And I like to do that before the suit, because if you transfer between spouses, you don't have to repay the ad valorem tax, right? So little things and tricks like that are totally worth going and talking to an attorney just to first double check. And then that attorney can advise you on the way to go forward. There are definitely attorneys out there who like big, expensive litigation, but most of us actually like to.
Yep, I think Reagan's frozen here. I think she would say that most of attorneys like to have cases that are, going forward in an amicable way, and that are getting good results for their clients without destroying the family unit. I think Patricia and Tori could attest to that as well. And Reagan, if you can hear us, you're welcome to log out and log back in. Sometimes this happens in this world of technology that we're living in. We're dealing with all kinds of stuff today, folks. Live events, don't we love them?
The fun of live events. One more final quick question. Is a mediation coach an attorney? Or what is a mediation coach?
Well, I will speak to that quickly, and then you ladies are welcome to answer anything you like here. Some attorneys I know do mediation coaching, which is basically consulting to kind of give you the lay of the land, and they may not be your mediator, but they're coaching you on what to expect and how to get your best outcome. And then there are specific mediation coaches out there as well. So it's just a matter of kind of finding the right person for you. So there may not be one specific, but that would be what I would look for. What would you ladies want to add anything to that?
Yeah, so sometimes I act as a consulting attorney for mediations. but often a coach is a mental health professional.
Okay. Looks like we've got a few more things going on here. And I do want to say that for privacy and for time purposes, because we have reached the hour, we don't want to disclose too many things. So Marcel, if there's any way for you to condense some of these very long questions here that we're seeing privately, I appreciate it.
There's just one more that I see. High conflict spouse, but want to do mediation. If I choose mediation before filing, do I have similar financial protections? So I'm wondering if there's, for example, does beginning with mediation prevent my spouse from selling stocks or the house? I'm not sure. I think it would depend what state you're in, first of all, but also we'll let our attorneys speak to that as well.
Right. Well, the goal of mediation is to reach a final settlement. And so if you finalized your issues, then there are no repercussions, right? Meaning that you've attended mediation with the advice of an attorney who's reviewed the documents before signing and executed the documents, et cetera. So the repercussions as to dispensing or being able to dispense with property would be a moot point, I believe, if I understand your question correctly.
I think from what I was reading, and it seems to have disappeared off my screen here, but that this person was saying they had not filed, Tori, that they were just going to go do a private mediation and try to work things out and then have attorneys draft the paperwork later. But in that instance, are they protected? Is there a stay order in place so that they aren't able to sell off stocks or move assets around and things like that?
That's the beauty of mediation, Lisa, is that you can language your particular concerns within the settlement documents. So if, for example, if you had a concern about selling stocks or divesting of stocks, et cetera, then you would language it so that there would be a temporary stay until the conclusion or the documents could be executed. So you can be as creative as you need to be at the mediation table.
All right, very good. That was an excellent question. Did you have something more to add to that, Patricia?
Yeah, and so in our state, as soon as a divorce is filed, we have an automatic temporary restraining order is put in place as to all the assets. So nobody can sell stocks, dispose of property. And so that's whether they're in mediation or collaborative or litigation. So in our first mediation session, we really talk a lot about the ATROS and that automatic temporary restraining order. So so that both parties are clear as to what they can and cannot do in the divorce process.
So the takeaways from all of this, folks, is that, do it yourself is very dangerous because you don't know what you don't know when it comes to the legalities and the financial matters of divorce. I will say that some of the most complicated areas that I see are employment perks, stock options, restricted stocks, performance share units. I've had so many people say to me, it's not that complicated, only to come back at the end and go, oh my gosh, I had no idea. And save people, potentially tens of thousands of dollars in taxes or a wrong move that might have hurt their credit or something of that nature. So combining the expertise of legal, financial, and emotional support in a divorce is vitally important to getting your best outcome. And we hope today that you have learned some tidbits and tips that will help you to understand why it's important to have legal representation in some manner, shape, or form as you're going through the process and getting through the finish line. And we are all here for you at divorcetownusa.com. Feel free to reach out to any of the experts here. Unfortunately, we seem to have lost Reagan, but Reagan King can also be found at divorcetownusa.com, as well as Tori White and Patricia Van Haren and myself, Lisa Decker. And it is our pleasure to have served you today. And thank you so much for joining us. Take care.
Thank you all.
Thank you.